We're back, and thank you for joining us. I appreciate you taking the time to watch today's program. If you find this analysis useful, your support makes a real difference in allowing us to continue bringing you these stories consistently and in depth. Today we're examining the situation surrounding Fani Willis and the very real possibility that she could face disbarment. To be clear, disbarment would mean the loss of her license to practice law. It would end her role as a prosecutor in Fulton County, Georgia, and effectively bar her from practicing law anywhere in the state. In practical terms, it would also make it extremely difficult, if not impossible, for her to regain a legal license in any other jurisdiction. What I want to focus on today is a crucial point that many observers appear to be overlooking. If Willis is required to repay funds from her office's budget to the Trump RICO defendants, whether that sum is $17 million or a far smaller amount, the legal implications are significant. Even a token repayment, $50 or $25, would carry weight. Any enforced repayment would substantially strengthen the argument that professional misconduct occurred, and that matters because it directly reinforces the case for disbarment under Georgia's legal and ethical standards. If her office is ordered to return money, it would validate the claim that rules were breached in a way serious enough to warrant disciplinary action. That, in turn, could lead not only to her removal from office, but to the end of her legal career altogether. Some commentators are treating this outcome as speculative or exaggerated. I disagree. When you connect the legal, financial, and ethical dots, this is not a far-fetched conclusion. If her office is compelled to repay any amount to Trump or the other defendants, it fundamentally changes the stakes of this case. So let's examine the conditions surrounding this situation carefully and walk through why this possibility is far more serious than many currently acknowledge.
Within the rules, there is a very small section that is dedicated to prosecutors. And frankly, I hadn't spent much time looking at it because it's never applied to me before. But I did look at it this morning, and it is Rule 3.8. It is the special responsibilities of a prosecutor. And within that, it says the prosecutor in a criminal case shall, and then it outlines A through I of things that they have to do to remain in the good graces of the state bar. And number one is they shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Now, you may be saying, oh, there it is. That's the answer. They did something that was not supported by probable cause. Well, there's an argument to be made there because Pete Skandalakis did say in his memo attached to his motion to dismiss the case that he did feel like there were some charges in there that should never have been brought. But the response, if I am Fani Willis or Nathan Wade, is, yeah, but I got it past the grand jury. It was indicted. An indictment is, in theory, a stamp of approval that probable cause exists for those charges. Now, we all know that, as I've said before, you can indict a ham sandwich. It's not that hard. They only hear one side of the story. So I think that an argument could be made there that maybe they knew that some of these charges weren't supported to a level of probable cause, but I just don't see that being, that gray area is gray enough that I don't see that as a situation where the state bar would say, hey, yeah, we need to disbar you over that.
That was attorney Megan Grout, whose analysis we've referenced on this program on several occasions. Her YouTube channel is linked in the description for transparency. In her assessment, she argues that none of the actions attributed to Fani Willis, at least based on what is currently known, rise to the threshold required for disbarment. That was the first clip. I'll play another shortly, but before we do, it's important to bring in reporting from the news itself, because this is a point I've been raising for several weeks now, and one that others appear either to have independently reached or begun to acknowledge. Take a moment to consider this carefully. Ms. Grout's central argument is that the act of bringing charges against Donald Trump, in and of itself, does not constitute prosecutorial misconduct. Her reasoning is straightforward. Willis secured an indictment. That fact alone provides a legal basis for the decision to prosecute. Even if the charges were politically motivated, a claim many have made, the indictment allowed Willis to argue that the prosecution met a sufficient legal standard to proceed. For the sake of argument, let's accept that position. Let's assume that disbarment would not be justified solely on the basis of bringing those charges. Set that issue aside for now. The more important question is this: were there other actions, separate from the decision to prosecute, that could meet the standard for disbarment? Were there additional failures, ethical breaches, or procedural violations that stand on their own? That is what we need to examine next.
Well, that's the $17 million question. 13 defendants in this criminal case, including President Donald Trump, say they should qualify for reimbursement under a new state law that applies in cases where charges are dismissed. So they've filed hundreds and hundreds of pages and receipts in hopes of getting their money back. But that'll be up to Judge Scott McAfee to decide whether they qualify, and if so, how much they'll get. So the new state law says it's only possible in a dismissed criminal case where the prosecutor is disqualified for misconduct. Here, DA Willis and her office were removed because of a, quote, appearance of impropriety. And several attorneys are raising questions about whether an appearance is enough to meet that standard.
This is the point I've been making for weeks. Fani Willis was removed from the Trump case not on the basis of proven misconduct, but because of the appearance of impropriety. That distinction matters, but only up to a point. If the judge now chooses to award attorney's fees to Trump or to the other defendants, he cannot do so arbitrarily. He must apply the law as written. And under that law, the return of legal fees requires a finding of misconduct. In other words, such an award would mean either that the judge himself has concluded misconduct occurred, or that he is relying on a prior judicial finding to that effect. That changes everything. Misconduct is not a cosmetic issue. It is a substantive legal and ethical failure, and it can form the basis of a formal bar complaint. More than that, it can support disbarment. It may well be argued that bringing the charges in the first place was legally defensible. That argument exists. What cannot be defended, however, is misconduct. There is no legal justification for it, no political excuse that neutralizes it, and no professional framework that tolerates it. If attorneys' fees are ordered to be repaid, that decision, by definition, signals misconduct on Willis's part. And once misconduct is established, the path to disciplinary action is no longer speculative. It becomes procedural. After all, if misconduct does not qualify as grounds for disbarment, one has to ask, what does?
Also, with regard to their personal conduct, again, distasteful, yes. In my personal view, improper and prosecutorial misconduct, yes, to a level in my view. However, I don't see that as something that's going to rise to the level of the state bar getting involved and then moving all the way to disbarment. And we need to also remember that in February of 2024, a watchdog group did try to file a complaint with the bar with regard to Fani and Nathan and their behavior. And as far as I can tell from my research, it was not successful. I say that because I can't find anything on it other than some news articles saying that it was filed. And that says to me that the bar took the complaint, the bar looked into the complaint, and the bar decided not to proceed. So for the most part, for what we have right now up through today, I don't see any way that the State Bar of Georgia would feel like there was conduct that required disbarment by Fani Willis or Nathan Wade.
One of the provisions most likely to be cited in any bar complaint arising from this situation is Rule 8.4, which deals explicitly with misconduct. Rule 8.4a states that it is a violation of the Georgia Rules of Professional Conduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Those categories define the core of professional misconduct, and this is where the issue becomes unavoidable. If attorneys' fees are ordered to be returned, the court is, in effect, signaling that something occurred which falls within that framework. That is not a symbolic gesture. It is a legal conclusion with ethical consequences. The return of attorneys' fees becomes the litmus test. If Judge Scott McAfee orders those fees to be repaid, it means either he, or a previous court on which he relies, has determined that misconduct took place. Once misconduct is established, the threshold for a bar complaint is met. That point is no longer debatable. What follows is a separate question. Would the outcome be disbarment, a formal censure, or some lesser form of disciplinary action? That remains uncertain, but if a court finds that a prosecutor engaged in misconduct, it is difficult to argue that no professional consequences should follow. In my view, if attorneys' fees are returned, a bar complaint is almost inevitable. Whether that complaint ultimately results in disbarment is not something anyone can state with certainty at this stage. What can be said, however, is that some form of action by the Georgia bar would be expected. To do nothing in the face of a judicial finding of misconduct would raise serious questions of its own. That is my assessment of where this leads. The key trigger is the fees. If they are returned, the legal and ethical machinery moves with them.